matter I have argued, one after case has been started and we have to take leave. The problem is this, only thing, this gentleman will go make hate speech, speaking about Hindu, Muslim, Hindu, Muslim, Hindu, Muslim. He will create another disturbance, but no one can start case against him. Kindly, my lord, consider if when your lordship has observed constitutional duties, discharging.
This channel does not promote any violence, harmful or illegal activities. All content provided by this channel is meant for educational purpose only.
In an area known as Mohisha, which is just at the edge of where the jurisdiction of Calcutta Police ends and the Diamond Harbour Police District begins. So the unfortunate incident, it had, but this what I am submitting is pursuant to the press conference which was held on behalf of the police administration. It had taken a communal flavor. Now the police has come up with a press conference stating that there are arrests which have been made. Now the temple was vandalized, people were injured, and accordingly, an application.
When this incident took place?
This had taken place, on last Thursday.
Date?
11th of June 2025.
Yes.
We had written to the SP of the concerned police district stating that the petitioner number 1, it is at page 46, the petitioner number 1, who is a member of Legislative Assembly from the opposition and happens to be the leader of the opposition, along with one more MLA from the opposition, they will be visiting the area to meet the victims. So this application was made on the 11th of June. Page
46 is the application. Yes.
Page 54 is the response. The SP responds by saying that as per information received, Honorable Leader of Opposition is going to visit Mohisha and Robindranagar area on 12/6 at 2 p.m. This is to bring to your kind notice that under section 163 BNS has been already promulgated to the entire Robindranagar PS area jurisdiction. It is requested that for maintaining peace and tranquility, please postpone today's visit at Robindranagar and Mohisha area. You may kindly fix up another date after revocation of 163 BNS Robindranagar PS jurisdiction.
Now, whether the 163 BNS order is still claimed?
Till today.
Till today.
But nowadays, an order has to be promulgated. The SP also has rightly said that it's promulgated. It is never published, What is available is, this, from the Twitter handle, of the West Bengal Police. It's just a tweet.
যদি শেষ হয়ে যায় আজকে তাহলে মামলা করিস কেন তোরা? মামলা করার জন্য মামলা করে না দেখে রিসার্চ না করে মামলা করিস কেন? মামলাটা নম্বর কত?
5 সেইখানে উপরে লেখা আছে।
না ওর লিপটা দেখে
না তোমার সামনে আছে রিপোর্ট।
নেই তোমাকে দেওয়া হবে কেন? মামলা করো কি ডকুমেন্ট পাওয়াচ্ছ? না দেবো, পরশু দিন দেবো।
So it is up to 16th of June, Mr. Doctor.
Yes, yes.
So today is 16th.
Today is 16 minutes. Kindly look into the
and what are the conditions mentioned in the order dated 13 June 2025? ABC.
Yes. এই আমাকে আরেকটা কপি দাও।
Give a copy to advocate.
I have it. Yes.
We do not have copies, Bharat.
No, why will I supply
There
a
is
copy?
a word.
There's a tendency, there's a tendency with respect.
Kali, my lord, the
Yes,
state has stopped
yes.
promulgating orders.
No, no,
Because, my lord,
now the conditions, the three conditions are assembly of 5 or more persons excluding persons on official duty.
Right.
Then carrying on firearms, stones, weapons, etc.
Yes.
Then any type of procession rally.
Yes.
Now these are the conditions, and these conditions are clamped till 16 June. Today is
Right.
16 June.
Right.
Now if the petitioner along with another MLA want to go for interaction with the local persons
Yes.
without organizing any procession or rally,
Yes.
then where is the difficulty?
But the first objection is, my lord, how does the leader of the opposition, he considers him to be a very big person, very well, let him consider him to be so, will have this unequivocal right, wherever some incident happens, then all his compassions rise and he has to go there. He will not go over there after another incident happens. Sondeshkali, whenever 144 he comes to court, the court gives him liberty. He goes over there, calls a police officer.
The state cannot go beyond
No.
what has
No,
been
no.
on record. Page
No.
54 is
Therefore,
not
Millard, please take this case. Please entertain this case. Whether Millard and on the promulgation of or on an issuance of Millard a 144 order, a
promulgation is also invalid.
163,
They are not
whether
published.
Millard somebody can maintain a repetition because the remedy is in the section itself. Please have a look to
But I
163.
have also annexed my lord similar.
Please have a look to it
not the
163.
first instance.
Yes. Kindly decide this point.
The point has been decided adequately by
Please, Millard, on this angle, Millard, kindly.
Division bench
Yes.
following Anuradha Basin.
Yes.
Yes. Paragraph 141, 142.
Yes.
Grateful.
Yes. Before that, Millard, please take Millard, what are the prayers? Please have a look to the prayers.
No, but the first thing is this, Mr. Dotto.
Yes.
This order is up to 16th of June. Today
Yes,
is 16th of June. If court permits the petitioner, two petitioners to visit the area tomorrow,
Yes.
then this order is not there.
Well, point is, Millard, somebody cannot come to the court, Millard, in the vacuum.
No. It has been
Millard,
responded to by order dated 46
Yes.
at page 46.
Yes.
So there is no vacuum. You have already made your
Millard,
stand very clear.
Millard, if he is aggrieved by the order of Millard of the communication, which is at page 54, Millard, please take Millard page 54.
Yes.
Kindly see the last sentence. You may kindly fix up another date after revocation. So let him say that I want to go on day after tomorrow or whichever date. Why is the court's intervention required?
No. Prayer is made since an order, request was made by the petitioners to visit the place. When referring to section, an order under 163 BNSS Robindranagar, this 163 BNSS, the prayer of the petitioner has been turned down.
Very well.
Now, subsequently, today a writ petition has been filed praying for permission so that the petitioners can visit the place and interact with the local people. Now, at today, it appears that the contention of the petitioner is found to be correct, that there was an order passed under 163 BNSS. Now, in 163 order, it is up to 16th of June.
Right.
5 persons, my lord. 5 or more.
Right.
Yes.
I do not accommodate myself within that.
First is, Millard, if this order.
You are yes.
Respond number 2.
Yes.
Maintainability of the petition itself is a
Yes. Well, please take me the section. Please take the section. Millard, a 144 or 163, if it is issued, well, the remedies, he may be aggrieved by the 163 order. Definitely he can be aggrieved. Millard, the lordship has found, Millard, from
163, yes.
Yes, 163. Can you have a look to 2?
Just a minute.
Yes. or I'll read the entire section. Kindly have a look to the entire section. In cases where, in the opinion of the district magistrate, a subdivisional magistrate, or any other executive magistrate is specially empowered by the state government, in this behalf, there is sufficient ground for proceeding under this section, and immediate prevention or speedy remedy is desirable. Such magistrate may, by written order stating the material facts of the case and served in the manner provided in by section 153, direct any person to abstain from a certain act or to do certain order with respect to certain property in his possession or under his management, if such magistrate considers that such direction is likely to prevent or tends to prevent obstruction, annoyance, or injury to any person lawfully employed, or danger to human life, health, or safety, or a disturbance of the public tranquility, or a right, or any offence. An order under this section may, in cases of emergency or in cases where the circumstances do not admit of the serving of due time of a notice upon the person against whom the order is directed, be passed ex parte. The order under this section may be directed to a particular individual or to persons.
Yes, so this is an order, Mr. Dotto, you are submitting in terms of 163(2).
Yes,
So it is ex parte order in case of in view of emergency.
right.
Now this ex parte order is subsisting till 16th.
Well, may I just complete this section? Then will not kindly see how to whom it can be directed, that is under subsection 3. To it can be to against an individual or to persons in an area, place, or to the public generally when frequenting or visiting a particular place or area. No order under subsection 4, no order under this section shall remain in force for more than 2 months from making thereof, provided that if the state government considers it necessary so to do for preventing danger to human life, so and so, so and
That is relating to extension of
extension.
beyond.
Now please take 5. Any magistrate may, either on his own motion or on the application of any person aggrieved, resigned or alter any order made under this section by himself or any magistrate subordinate to him or by his predecessor in office. And 6 is, the state government may either on its own motion or on the application of any person aggrieved, resigned or will alter any order made by it under the proviso to subsection 4. This is the extension part. Then 7, when an application under subsection 5 or subsection 6 is received, the magistrate or the state government, as the case may be, shall afford the applicant an early opportunity of appearing before him or it, either in person or by an advocate, and showing cause against the order. And if the magistrate or the state government, as the case may be, rejects the application wholly or in part, he or it shall record in writing the reasons for doing so. Therefore, my lord, if my learned friend is aggrieved by the 163 order, my lord, the remedy is in the statute itself. Remedy cannot be made by way of a writ petition. So, my lord, if he says that 164 is preventing my fundamental right, which is ordinarily said, now if it prevents it,
But Mr. Dotto, in similar cases, our single benches, division benches passed order.
yes.
So
My lord, in similar cases, my lord, your lordship kindly
identical issue has been considered and order has been passed.
yes. But my lord, please consider, my lord, whether this point has
If today court
Yes.
directs, permits the petitioner, two petitioners along with their security personnel to go the place and interact,
Yes.
then how you are prejudiced?
No, it's not a question of prejudice. It is a question of, my lord, crossing the threshold limit. Whether, my lord, this kind of a writ petition your lordships would entertain or not, my lord, despite the remedy being under the statute and the section itself, my lord, please consider this. Well, otherwise, my lord, the court will be burdened with all this. My lord, I have a right to go anywhere I like.
Yes,
I have a right.
that is 19(1)(d).
Yes. Now, my lord, if I have a right, whether, my lord, this right is completely, my lord, an unfettered right, or, my lord, this right is subject to reasonable restrictions or not. My lord, Article 19 itself, my lord, provides that, my lord, there can be reasonable restriction to this right. And, my lord, the courts have held that 144 or now 163 is one of those reasonable restrictions. But otherwise, what will happen?
Yes.
But any order under 144 or any order under 163 is susceptible to, my lord, affect any or a single person's right. Well, your lordship cannot come across any order under 144 or 163 which does not affect anybody's right. And the right that is sought to be projected to be affected is the right of free movement. Now, if the right of free movement is always ensured, Milord, divorce the Milord object of the statute, then Milord, it would be very difficult for the administration also to function. But the administration has not denied. The administration says that, okay, fix another day. It is not a case of denial, or it is not a case of obstruction of somebody's fundamental right to move in any direction. So, Milord,
Now, Mr. Bhattacharya, do you want to bring on record this? Yes, I will hear. Do you want to bring on record this order?
But the order has not been
No,
promulgated.
I will direct them to supply a copy of the order. Because this is not part of the writ petition.
not part
You have
of the-
mentioned this order in your writ petition.
We have gathered our knowledge from
Yes.
the ex-hand, and we have
54,
communicated.
Because
54.
today,
Oh,
Mr.
JK
Dotto is
Shekhar
inviting
Shekhar.
this court to consider the
Uh,
merit of
uh,
this order, the
But
validity of this order.
We may consider the merit, my lord, even without looking at the order, my lord. I think, my lord, I will be having a reasonable reply, my lord. I'll wait for my esteemed senior friend also, my lord, to advance his arguments. I'll be dealing.
So it is not necessary to bring on record this copy of the order question
The
by
order,
way of a supplementary
the
affidavit.
order is applicable, my lord, in respect of an assembly of 5 or more persons. My case is, my lord, I do not come within the ambit of that particular order, but the SP has acted ultra vires the provisions of not only the Constitution of India, as well as ultra vires provisions of this particular order, because he is attempting to apply an order which is not admittedly applicable to us, to 2 persons. That is my case, my lord. I squarely come within para 15 of my lord, Whirlpool's case, my lord. That is the 1998, volume 8, Supreme Court cases, page 1.
Can I meet?
Please consider one line reply. One line reply is whether Milord Walpole's case would apply in a case where there is a parallel law which permits reasonable restriction to be applied.
That's an only alternative.
Where there is only alternative remedy except that nothing is there, here Milord, it is a reasonable restriction. The Supreme Court has Milord considered these points and has said that an order under 144 is a reasonable restriction. Way the right of free movement.
But one thing, Mr. Dotto, this order which has been passed on 16 March 2025, it says that assembly of 5
Yes.
and then carrying of firearms, then any type of possessions.
He has no
If these
cause of
things,
action.
if these
He-
things,
then
if
he
these
has no
things,
cause of action.
if these things are complied with,
Yes.
and the petitioners are permitted to visit and interact, then what is it?
No, why
the
the
parameters
no,
within the
can I just-
parameters?
Can,
Yes,
can I just
within the
say-
parameters laid
I-
down
I
by
will-
the
I'll address
laid
this.
down in the order.
No,
then
I
it
will
be
address why the court blessings is required. Why the court blessings is required?
because
No, nothing.
no. The
Come to
police
prayer.
authority has refused the prayer of
No,
the petitioner.
no. Why he will make the prayer?
Why not?
Why? No. If
Mr.
163 is there,
Why
no,
not?
no. The question doesn't come to his prayer. He is aware about 163 order. Come to the prayer first, page 34.
Yes, he has not.
My lord, this is a weapon for just publicity. If you think that I will go with 2 persons, you don't need a permission. Why you have written this letter? If you have an honest intention,
No, sir.
my lord, kindly just
Yes.
one by one, kindly do not jump into the last. Let us go from the step by step. First, kindly come to page 47. Where is under which law it is required? Why you have sent it? You are coming up before a high court under Article 26 for enforcement of your right. It's a mandamus. Under which law? Under which law? Why the High Court will interfere? If 5 up to 5 is permitted, you can go. So why the court's blessing is required?
Please come to page 54.
I am coming. First is page 47. These are
Since you are
since
you are
simply
you are
because not simply because you have
submission
Well,
that why it is required.
no simply because he has written the letter.
Why it is required? Because it is required in view of page at page 54.
What? No. Page 47 is not before page 54.
No,
Page
no,
47 is, my lord, page 47 is first or not?
Yes, this is an application. Page
Why? Under what law? It's a mandamus. Enforcement of legal right. What is that law? And you are aware about the fact that 144 is there. I mean, now the 163. His prayer is itself is this. But that every time a political leader will take the court blessings and go to the public, because of the court I have come here, this is also not permissible. My lord, kindly do not allow this forum to be utilized politically. If it is not required, your lordships have correctly observed. He can go, two persons will go. What is the difficulty? There is no difficulty. Until he does any illegalities, if he commits any illegalities, we will take steps. And we cannot take steps because of the High Court's blessings. No FIR can be lost against him anywhere. High Court has passed an order, and 3 years this is there. He will go, he will do everything, he will activate criminal activities, he will get slogan, he will do everything. He can file any cases, 1,000 cases, but against him, not a single case is allowed. High Court blessing is there.
Yes.
Therefore, he was not required to. My lord, why the Reed Court? Why I am arguing, I tell you, lords. Why the Reed Court will exercise the power? If 16th is last, it has become infructuous. For tomorrow, your lordship is not required to pass an order unless 163 order is passed first. Why your lordships will give the blessings to him? Is he a Superman?
No, to ensure the right guaranteed under.
No, to ensure means
part 3.
my lord, kindly now where is this? Where is right has been infringed? My lord, your lordships. My lord, your lordships.
In a legislative assembly is being prevented to go to a particular place.
Where he has been prevented. My lord, where he has been prevented. My lord, a leader of opposition does not enjoy any extra status other than the. My lord, kindly. My lord, that is the incorrect impression are being carried by few judges of this court. Leader of the opposition are not privileged persons beyond the assembly. My lord, sorry.
Don't make aspersions against any judges.
No, it's all right. All the time.
Not accept very.
No, that's all right. If you may not like me, that doesn't matter. But leader of the opposition is not God. Every time your lordship's court is saying, where is it?
Today, if the order passed in terms of 163 BNSS does not make any prohibition for visiting the petitioners to a particular place as it appears, then why you are
why he has made
why you are making an argument in order to prevent?
I cannot understand, my lord. I am sorry. Kindly excuse me. Your lordships will take the exception. Unfortunately. No. Unfortunately, your lordships will take the exception.
What I am just.
No. Your lordships. No. That is it. This is being done. Kindly do not indulge anything from this institution for giving a political thought, which is going on.
Yes.
Unfortunately, it is there. Now, first, let us come to the law. Let us come. Let us come to the law.
The order, yes.
If
it is required, then the order.
Unfortunately, I could not make myself clear.
No. Yes. Very much clear, Mr. Bandyopadhyay.
I am very dull-headed.
You are a seasoned advocate.
I am not intelligent.
You are arguing for last 10 minutes. You have made your client stand absolutely clear.
Not clear.
Now,
but still, your lordship asking the questions. Therefore, I am not making my
the first question under 163 BNSS does not make any prohibition. So far, the visitation of the petitioner is concerned to that particular locale.
Yes.
Then why you are arguing this matter?
No, I am not. Why he has made this application?
Because in view of the previous order.
What is previous order?
Now there was an order passed by under section 163 BNSS. That order was not part of the writ petition. Now it has been rightly stated in the writ petition that order has been passed under section 163. Now 163 order has been.
Then in that case, your lordships have to take it. In that case, your lordships kindly give time. In that case, we will show the division bench order. He was not allowed to enter.
Very well.
Yes, please, Mr. Bilodal Bhattacharya, Mr. Bilodal Bhattacharya, have your presence. You have come up with your all friends, central government agency in such a matter. You have come up with it all, served everyone. We know about what is the modus operandi. We know about all this. Now, Milord, no, go. Why the court blessing? Why the court blessing is required? My point is, Milord, will you allow? Or Mr. Bhattacharya, I will not allow you to make submissions if you go on continuing this until I finish it. And what will be happen when you will be elevated as a judge? At least don't sit in Calcutta High Court. Fully political you would be. Milord, yes.
I think
No,
this
no.
discussion can be carried on at the corridor.
No, there's any discussion can be carried on.
Yes.
Any discussion can be.
Yes, yes.
Milord,
Yes, Mr. Bandyopadhyay.
first, Milord, 163 does not, 163 anyone can go. Right? Subject to the condition up to 5. There, he didn't make the application. Who has made the application? What he is trying to do? What he is trying to do? Request to allow Sri Subhendu Adhikari, Honorable Leader of Opposition, West Bengal Legislature, along with one MLA and their central security personnel to visit Mohisha under Rabindranagar Police Station. As per the directions of I1, will meet with
Well,
the
I
detective.
am directing the petitioner to make an application in course of this day and allow him tomorrow.
Why the application is needed? I don't understand that.
Allow him tomorrow. Because apparently there is no restrictions in the order dated 13 June 2025 if less than 5 persons go there.
Yes, no. Then in that,
Within the parameter,
Milord, in that case, why,
within the
Milord,
parameter
I'm
of-
sorry, my lord.
within the
In-
parameter
in
of
that
the-
case,
please allow this court to express its mind also. Within the parameter of the order dated 13 June 2025 issued by the subdivision magistrate, I will permit them to go within the parameter.
Can I make submission then?
Yes.
Therefore, Milord, your lordship wants to give him blessings.
No.
And that's
why
right.
should I?
Political blessings. It will be.
Not a political.
No, naturally.
Cannot-
Why the High Court will entertain a petition?
No.
No, High Court will entertain a petition. Why the High Court will entertain a petition when 16th is there, 16th is last? Why
Yes.
your lordships want to give the blessings?
No,
That
it's
would
not
be
a
for
question
the.
of giving
No, that's right. It's a blessing.
Mr. Bandyopadhyay,
It's a blessing.
application was made. This was turned down by the concerned.
Not
officer
turned down.
in reference to 163 order. Now 163 order has been placed before this court. On perusal of 163 order, it appears that within the parameters, issue can be sorted out. And since the prayer of the petitioner at first was not allowed, permit him to visit the place in order to give sanctity of the constitutional right which every citizen enjoys.
But I do not understand why lordship is perceiving that we are destroying the constitutional right.
Being a
These
court
are
of equity and
unfortunately-
constitutional court,
No.
court considers this from the angle of Article 90.
I just said, Milord, we are in the, your lordship is a constitutional court, but we are also, Milord, know something about the constitutional law. Unfortunately, I know something little about the constitutional law. And your lordship is the constitutional guardian.
Yes.
I know that your lordship's knowledge is far better than me in the constitution. That is no problem of that. Question is whether the court will pass an order when there is no cause of action.
Because cause of action is there.
Nothing.
What Mr.
Nothing.
Bandyopadhyay is submitting in this
Nothing.
this is the page 54. Page
Why the page
page
16?
Yes, yes.
No. Page after 16 there is nothing. No order is there.
Page 54 order is there
Page,
by your superintendent of police.
Superintendent of Police passed an order on the basis of his application. Was the application was warranted?
No. Application was
My
made
lord,
on behalf
whatever
of-
I am submitting, your lordship is saying no. Whatever he is submitting, your lordship is yes.
said anything.
So very nice. I am so grateful. Pass your order. But today my impression is something that so far state of West Bengal is concerned in such a matter, your lordship will say no, your lordship will say yes to Subhendu Adhikari. You may take exception to my knowledge. This is not correct that when when this is the reason I do not decide. Milord, do not. If this is said, no. If this is said, if this is said, if this is said, I will file an affidavit. I will file an affidavit. There is no communal violation. Come to this.
Well, I keep this matter pending.
Yes.
You file your affidavit.
Yes.
Submit a report.
Yes.
But in the meantime, permit it.
If he is
How you are prejudiced, Mr. Bandowad?
no, that's all right.
Because not in violation of the order passed in one city.
But I do not understand. No, I am not prejudiced. Why your lordship is giving a handle to a things which is not
No, it's not a
your
question of
lordship
giving
is,
handle.
No, 60. Why is the? I would have thought that your lordship asked the question why you have made this application. Why this application has been made?
But court will
Because if today,
will not
because I am
respond
a political
strictly
man.
in terms of
Pardon?
your thoughts.
Pardon? No.
Will not respond
That is
strictly
then the court is very much overzealous to the state is concerned.
Yes.
Then the court is overzealous to the state is concerned. Sorry. If court thinks that it will be happen, then court is overzealous to the state is concerned. I'm very sorry.
That if that
My lord, I will also kindly
this is
see.
your perception, then
No.
you keep with this, go on with this perception. Court is not going to mend you. It is not court's duty. What is passing through your mind, you have stated. But what I find from the record and
my lord,
your submission,
I do not.
I'm expressing my mind.
My lord, I do not understand. We are also political persons. We also move it. 144 is so many places. We go meet. We don't file an application. Why? If more than 5 persons we go, we file an application to the police. Allow us. And every time, whenever this application will be, Suvendu Adhikaris will come, the court will entertain in a vacuum place, whatever Mr. Advocate General has said, submitted. There's nothing, no cause of action. There is no cause of action.
But may I submit one thing?
Yes.
Your lordship may keep this matter pending without. Let us come back day after tomorrow. Tomorrow, if he wants to go, he may go. Kindly not make any observation. Kindly not make any observation. Keep it day after.
No, I am keeping this matter pending. In the meantime, I am granting leave to the petitioner to attend the place, and I also direct the authorities to ensure that no untoward incident takes place.
No untoward incident means what? If he creates an untoward incident, what will be what we will do?
In that case, we need to place certain things on record. But this is a matter of record. It is in the record of the High Court. Because in Sandesh Khali, 144 orders were passed. The court watched the 144 orders and he needs to go. He goes over there and calls a police officer. It's on record.
My lord, that is far from the truth, my lord. The state filed an application which has been withdrawn by the state.
Yes,
My
it
lord.
may be
The state cannot say that he called someone this and that. This is highly objectionable, my lord. Had it been an individual, had it come from an individual, my lord, it was something different.
So it is not a case where court is required to go into the niceties of the order passed under 163.
Yes.
Because within the parameters as contained in the order under section 163, petitioner can be permitted. Let him go visit and come back.
The problem is,
Visit
there are
and come
various
back.
problems. Number one is the court cannot control his activities. Number one. Number two, if his activities are beyond what is required, we cannot take any action because we cannot lodge any FIR. Number three, hate speeches this person gives everywhere, every day.
We cannot raise.
We cannot take any action. These are the impediments. Number four,
These are, my lord, wild allegations, my lord. There is not a single contempt application, my lord. Not a single contempt. This, my lord, is the submission, the common submission in each and every case. I have to knock the doors of justice, my lord, in each and every case. The latest thing, my lord,
This is also incorrect. I am contesting the matter. I have argued. One after case has been started and we have to take leave. The problem is this, only thing, this gentleman will go make hate speech, speaking about Hindu, Muslim. He will create another disturbance, but no one can start case against him. Kindly, my lord, consider if when your lordship has observed constitutional duties, discharging, restrain him not to pass any comments. According to him, it is a communal things have been done. And if he commits anything, give us leave to start case against him.
That how can I already he's enjoying an
No, that's the problem. That's the problem. 3 years, 4 years are going. Your lordships will say, don't blame. But what can I do? 4 years interim orders. Argued the matter in December 2023. Judgment has not yet been delivered.
Even in the recent Murshidabad riots also, my lord.
Murshidabad riot, you have tried. My lord,
And I had to visit, my lord.
no, Murshidabad.
From the
No, Murshidabad riot.
tried this, my lord, at the time of Sandesh.
Murshidabad riot. No, Murshidabad riot, you are on the very first day, you didn't get any order. Tell the truth. You have asked for 355, you didn't get the order. You have passed an order for the this NIA, you didn't get the order. After 1 month, 15 days, division bench presided over by Justice Sen passed an order, only allow him 2 persons to go.
That is my prayer.
No, 10 booths. After 1 month, 15 days.
Yes.
After 1 month, 15 days. Not on the very first day. Not on the very first day.